This Constitution was not meant to include American citizenship for those of African descent, be they enslaved or free. This is the story of Dred Scott and his family, enslaved yet fighting for American citizenship. Dred Scott was born into slavery around 1799 in Southampton County, Virginia. In 1818, he was taken to Alabama with 5 other slaves by Peter Blow. They worked on the Blow farm near Huntsville, but the farm was unsuccessful. In 1830, the Blows gave up farming and moved to St. Louis, Missouri, where they opened a boarding house. They sold Dred to Dr. John Emerson, an Army surgeon. When Emerson was assigned to Fort Armstrong, Rock Island, Illinois, he took Dred with him. Dred did not like Emerson and ran away in 1836. He was captured in Lucas Swamps, Missouri, and taken back to Fort Armstrong. As an Army officer, Emerson moved frequently, taking Scott with him to each new Army posting. In 1837, they arrived at Fort Snelling in the slave-free territory of Wisconsin, later the state of Minnesota. It was at Fort Snelling that Scott met and married Harriet Robinson, owned by Lawrence Taliaferro. As Justice of the Peace, Taliaferro married them. This is significant because in the slave-free state, marriages were binding between blacks. Slave marriages were not binding in America and did not require formal vows. Scott used this fact to credit his case for being free. After the marriage, Taliaferro transferred ownership of Harriet to Emerson. He continued to treat the Scotts as his enslaved. When Dr. Emerson was transferred to Fort Jessup, Louisiana, in 1837, he left the Scotts at Fort Snelling, leasing out their labor for his financial benefit. In February 1838, Emerson married Eliza Irene Sanford of Louisiana. They called the Scotts to join them. They arrived in Louisiana, but Emerson was reassigned to Fort Snelling later that year. The Emersons and Scotts returned to Missouri, a slave state, in 1840. En route on a steamboat, Harriet Scott gave birth to their first child, Eliza. In 1842, Emerson left the Army and went to Iowa Territory, where he died in 1843. Irene, his widow, inherited his estate, including the Scotts. For 3 years, she leased them out, dependent on the income from their labor. In 1846, Scott asked to purchase his family's freedom, offering $300, but Irene Emerson refused his offer. Feeling entitled to their freedom, Dred and Harriet filed separate freedom suits in St. Louis Circuit Court for the family. The cases were later combined by the courts. They claimed that freedom was granted when Dred lived in Free State, Illinois, and the Free Wisconsin Territory for 4 years. The laws stated that those jurisdictions, slaveholders gave up the right to slaves if they stayed for an extended period. The Scott versus Emerson case was tried by the state in 1847 in the Federal State Courthouse in St. Louis. The Missouri Circuit Court upheld the precedent of once free, always free. That is because the Scots had been held voluntarily for an extended period by their owner in a free territory, which provided for slaves to be freed under such conditions. Therefore, the court ruled they had gained their freedom. The Scots enjoyed living as free Americans until 1852. Irene Emerson appealed the verdict, and it was heard in Missouri Supreme Court, where they struck down the lower court's ruling in 1852, arguing that because of the free state's anti-slavery fervor, it encroached on Missouri. Therefore, the state no longer had to defer to the laws of free states. It said that Scott should have filed for freedom in Wisconsin Territory. By this decision, the court overturned 28 years of precedent in Missouri. On March 23, 1852, the day after this Missouri Supreme Court decision had been announced, Irene Emerson's lawyers filed an order in the St. Louis Circuit Court for the bonds signed by the Blow family to cover the Scots' court costs be returned to them with the slaves and their wages earned over 4 years, plus 6% interest. On June 29, 1852, Judge Alexander Hamilton overturned the order. Henry Taylor Blow, the son of former owner Peter Blow, had paid the Scots legal fees up until this time, but the family could no longer afford to do so. In 1853, when Scott again sued for their freedom, this time under federal law, the case was undertaken pro bono by Roswell Field, who employed Scott as a janitor. Irene Emerson had moved to Massachusetts and transferred Scott family ownership to her brother, John F.A. Sanford. In addition to the existing complaints, Scott alleged that Sanford had assaulted his family and held them captive for 6 hours on January 1st, 1853. Because Sanford was a citizen of New York, the federal courts had diversity jurisdiction over where the case could be heard. They chose Missouri. In 1854, Judge Robert William Wells directed the jury to rely on Missouri law on the question of Scots' freedom. Since the Missouri Supreme Court had ruled that the Scots remain enslaved, the jury found in favor of Sanford. The nation, North and South, followed the legal journey of the Scots with vocal outrage. From areas occupied by free blacks, political and business leaders heard their condemnation. Most vocal were Northern abolitionists, black and white, pressing their agenda that all men be free. They held breath awaiting the decision. President-elect James Buchanan wrote to his friend Supreme Court Associate Justice John Catron to ask whether the case would be decided by the court before his inauguration in March 1857. Buchanan hoped that the decision would quell unrest in the country over the slavery issue by issuing a ruling to take it out of political debate. He later successfully pressured Associate Justice Robert Cooper Greer, a Northerner, to join the Southern majority in Dred Scott to prevent the appearance that the decision was made along sectional lines. There is no legal evidence that John Sanford owned the Scots. When the case was filed, the two sides agreed on a statement of facts that claimed Scott had been sold by Dr. Emerson to John Sanford. But Emerson died in 1843, and the Scott case was filed in 1847. There is no record of Dred Scott's transfer to Sanford or of his transfer back to Irene. Scott is never listed in Sanford's estate records as owning him. Also, Sanford was not acting as Dr. Emerson's executor, as he was never appointed by a probate court, and the Emerson estate had been settled when the federal case was filed. The Supreme Court heard arguments in the Dred Scott versus Sanford case. On March 6, 1857, Chief Justice Roger B. Taney delivered the majority opinion. Taney reported on three major issues: that one, any person descended from Africans, whether slave or free, is not a citizen of the United States, according to the United States Constitution. Number two, the Ordinance of 1787 could not confer either freedom or citizenship within the Northwest Territory to non-white individuals. Number three, the provisions of the Act of 1820, known as the Missouri Compromise, were voided as a legislative act, since the act exceeded the powers of Congress insofar as it attempted to exclude slavery and impart freedom and citizenship to non-white persons in the northern part of the Louisiana Purchase. The court had ruled that African Americans had no claim to freedom or citizenship. Since they were not citizens, they did not possess the legal standing to bring suit in a federal court. As slaves were property, private property, Congress did not have the power to regulate slavery in the territories and could not revoke a slave owner's rights based on where he lived. This decision nullified the essence of the Missouri Compromise, which divided territories into jurisdictions either slave or free. Speaking for the majority, Taney ruled that because Scott was considered the private property of his owner, he was subject to the Fifth Amendment to the United States Constitution, prohibiting the taking of property from its owner without due process. There were two dissents, Justice Benjamin Robbins Curtis and John McLean, who filed very different opinions. Curtis's 67-page dissent argued that the court's conclusion that Black people could not possess federal United States citizenship was legally and historically baseless. Curtis pointed out that at the time of the Constitution's adoption in 1789, Black men could vote in 5 of the 13 states. Legally, that made them citizens of both their individual states and the United States federally. Curtis cited many state statutes and state court decisions supporting his position. His dissent was extremely persuasive, and it prompted Taney to add 18 additional pages to his opinion in an attempt to rebut Curtis's arguments. McLean's dissent deemed the argument that Black people could not be citizens more a matter of taste than of law. He attacked much of the court's decision as obiter dicta that was not legally authoritative on the ground that once the court determined that it did not have jurisdiction to hear Scott's case, it should have simply dismissed the action rather than passing judgment on the merits of the claims. Curtis and McLean both attacked the court's overturning of the Missouri Compromise on its merits. Curtis further stated that slavery was not listed in the Constitution as a natural right, but rather a creation of municipal law. He pointed out the Constitution said, quote, "The Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state." Since slavery was not mentioned as an exception, he felt a prohibition of it fell within the scope of needed rules and regulations Congress was free to pass. As imagined, the court's decision created a stir across America. Newspapers reported that Scott is still a slave. Lawyers in every state were forced to pay attention to race and slavery in the law. Leaders across the country were forced to admit that the slavery problem was coming to a head and war may not be overruled. Abraham Lincoln expressed the opinion that on the judicial decision in the Dred Scott case, "I yield obedience to the decisions in the court, to the final determination of the highest judicial tribunal known to our Constitution." But in a speech in Springfield, Illinois, Lincoln responded that the Republican Party was not seeking to defy the Supreme Court, but he hoped they could convince it to reverse its ruling. Note that in 2017, the Maryland State House removed Judge Tandy's statue from the grounds. But this was not the end of the Scott story. Irene Emerson moved to Massachusetts in 1850 and married Calvin C. Chaffee. He was a doctor and an abolitionist. He was elected to Congress on the Know Nothing and Republican tickets. Following the Supreme Court ruling, pro-slavery newspapers attacked Chaffee as a hypocrite. He protested that Dred Scott belonged to his brother-in-law and that he had nothing to do with Scott's enslavement. Nevertheless, the Chaffees executed a deed transferring the Scott family to Henry Taylor Blow. Chaffee's lawyer suggested the transfer as the most convenient way of freeing the Scotts. Blow filed the manumission papers with Judge Hamilton on May 26, 1857. The emancipation of Dred Scott and his family was national news and was celebrated in northern cities. Scott worked as a porter in a hotel in St. Louis, where he was a minor celebrity. His wife Harriet took in laundry. Dred Scott died of tuberculosis in 1858. Harriet died in 1876 after seeing the end of slavery for all Black people. It took a civil war, many lives lost, to free the enslaved. The 13th Amendment of the Constitution, legally freeing them, was passed in 1865. The 15th Amendment granted them citizenship by right of birth and jurisdiction in this nation.